Thank you very much, Mr. Vice President. Mr. Vice President, a couple of terms have been used in the response from the other side that I would like to address briefly. One term which has been used by Senator Mark is the term regulatory capture. It is a misapplication of that term, and I would like to put it into context. What we are about here today is an amendment to the Civil Aviation Act to enable the term of a board not to be limited as it presently is by Schedule 2, subsection 2, and therefore to enable the members, any one or more, not all, the members of the board to be eligible for reappointment. There is nothing in that concept, nor in that present context, that is at all relevant to the misapplied term regulatory capture. In fact, and on the contrary, there is ample precedent in our legislative instruments passed by this Parliament in the Republic of Trinidad and Tobago, which speaks to the normalcy of boards being eligible for reappointment. I will give only a few examples. The Occupational Safety and Health Act, second schedule, paragraph 3. The appointment of a person other than the executive director as a member of the authority shall be for a term of 3 years, but outgoing members are eligible for reappointment. The Regional Health Authorities Act, Chapter 2905, second schedule, paragraph 2, subsection 1, subparagraph 1, speaks to the appointment of members being for a period not exceeding 5 years. So the limit is placed, not exceeding 5 years, as the President may specify at the time of the appointment, and those members are eligible for reappointment. The Securities Act, Chapter 8302, Section 12. Subject to this section, a commissioner other than a temporary commissioner shall hold office for a period not exceeding 3 years and shall be eligible for reappointment. The Children's Authority Act, Section 46, number 10, a member shall hold office for such period as stated in his instrument and shall be eligible for reappointment. The Trinidad and Tobago Electricity Commission Act, Section 4. A member shall hold office for a period not exceeding 5 years as the President may direct, but a member of the Commission is eligible for reappointment. The Environmental Management Act, Chapter 35, number 5, Section 82, subsection 4. All members of the Commission shall hold office for such term not less than 3 years and shall be eligible for reappointment. The Town and Country Planning Act, first schedule, the members shall hold office for a period not exceeding 2 years, but such member shall be eligible for reappointment. And the Port Authority Act, Chapter 51, number 1, members holding office for a period not less than 2 nor more than 5 years, but any commissioner shall be eligible for reappointment. So the precedent is ample, Madam President, for the reappointment of members of a board. And what we ask this House to do is, by the amendment which we ask that this House should pass, to enable one or more members of the board of the Civil Aviation Authority to be eligible for reappointment, having regard to all of the reasons to which I have earlier spoken, none of which I shall repeat, but only to emphasize the continuity of accessibility to proven experience, competence, and in the interest of the safety of the civil aviation industry. Senator John spoke, if I may pass on to one other point, Senator John spoke to the fact that the minister is responsible for the administration of the act, and it seemed to me that she was suggesting that that is to exist independently of the board. But the short point is that by section 15 of the act, it is the board which must manage and advise the minister throughout their tenure so that he can perform his functions under the act with the competence of the proven, skilled, and specialized experience which the board brings to the functioning of the Civil Aviation Authority. I believe it was the Honourable Senator Dr. Dayal Singh who spoke to the fact that there was availability of the hiring of old board members as consultants, in a suggestion that the bringing on board of new members could not speak to the competence of reappointing present members of the board. I hope I didn't get him wrong. But the short point is really that the members of the board are not available after the expiry of their term to function as consultants in relation to other persons acting under the regulatory authority of the Civil Aviation Act. And that therefore imposes its own limitation on the availability of members of the expired board. And very interestingly, Madam President, a term was used in this honorable chamber to suggest an intention of this bill which we bring for purposes of deleting by amendment the limit on the term of the members of the board. And as is his wont, it was used by way of misapplication and inappropriately, but it reminds us of a very poignant period of public outcry in this country, and it is perhaps relevant as I close for us to remind ourselves. The term was used by Senator Mark to describe this amendment as being ad hominem. And this House will record the law reports 2016 UK PC number 2 in the matter of Steve Ferguson, Maritime Life Caribbean Limited and Amir Edu, judgment of the 26th of January 2016, which is the locus classicus in this jurisdiction for the real meaning of ad hominem legislation, the infamous Section 34, passed by the members of the other side. Against that background, Madam President, it really is for me to say very little more. I think I have spoken enough. I compliment the commendations and the contributions of the members on the government side. I am indebted to Senator Vera for a term that he used, and I will end by invoking, with his permission, the term that he used to describe the bill which we bring to this House, and the term was, the amendment will improve, not impair. And with those words, I beg to move, Madam President.
Honourable Senators, the question is that a bill entitled An Act to Amend the Civil Aviation Act, Chapter 4903, be now read a second time. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Civil Aviation Act, Chapter 4903.
Attorney General.
Thank you, Madam President. In accordance with Standing Order 661 I beg to move that the Civil Aviation Amendment Bill 2022 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Civil Aviation Amendment Bill 2022 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause.